Okay, welcome everybody to the Saturday night civics and sovereignty class presented by the Vocational Science Freedom. And tonight we'll be covering the task committees for the Vocational Science Freedom, how we want to organize them, and I'll go over again the various different sections that will be starting off for people that want to join the task committees and the offices that will be each chair and also the special master, and I'll explain, and the scribes, and explain what each of those positions are. And then I'm going to be covering a document, a court case from 1855 called Ex-parte Knowles, of which we'll cover the importance of the difference between a federal citizen of the United States under the 14th Amendment and a de-jure state citizen, and that the power of being able to naturalize a citizen has never been with the federal government. And I'll show that in the court case. And if you are new to the Vocational Science Freedom, you are listening to this online, you can join the Vocational Science Freedom Gilded server by coming to the Vocational Science Freedom YouTube, or if you're watching this on Odyssey or have this as a post on Gab, the Gilded server link will also be in the show notes for every episode, and it is also on the banner on the Vocational Science Freedom YouTube page in the upper right hand corner. You can click on it, and then when you set up your account, and I highly suggest you download the app and run it off the app instead of running it on the web browser. Once you join, there'll be a little apply button right here in the banner, and you want to click apply and then answer the questions, and then you can join in the discussion in our Gilded server. So I dropped a link for the document that we're going to be covering tonight. It's Ex-parte Knowles, and I'll blow it up a little bit so that everybody can see it, who's ever watching on the live stream, and we'll go over this. And I want to cover this because the importance of it is about the power to naturalize, but it also has a lot of other interesting bits of information in this court case, because this court case was July of 1855. So this is pre-Civil War we're talking about here, okay? When the understanding of the common law and the difference between common law and equity and the common law and statutes was clear in everybody's mind, and the attorney hadn't completely muddled the two of them to take over our entire republic. So, ex parte Knowles. All right. The power to naturalize is made a judicial power by an act of Congress. Congress cannot confer any judicial power upon a state court. The provision of the Constitution of the United States which gives Congress the power to establish, quote, a uniform rule of naturalization, close quote, is construed to mean that the rule, when established, shall be executed by the states, not by the federal government. So only the states are the ones who can then establish and execute a naturalization. Now, have they been doing that? The answer is no. Because what the federal government does, is they have everybody naturalized as a 14th Amendment citizen, which is subject to the jurisdiction of Congress. And I'm going to get into the remedy that we can use to force the states to acknowledge us as one of the people of those states, and thereby removing us from all of the jurisdiction of the feds automatically. I don't know how many pages this is. I don't. It's not too long, but so anyway, we'll get through this, and I'll describe the remedy and what we're talking about here. Under the Act of Congress of 1802, quote, every court of record, right? So that's a court of record is a court that proceeds according to the course of the common law, right? Not according to statutes. Every court of record in every individual state having common law jurisdiction and a seal, which is the main important reason why everybody has to make their own house seal, so you can have your own seal for your own court, because this is what they're talking about. And clerk or prothonotary shall be considered as a district court within the meaning of this act. So what did they do? The feds said all the courts of records in the states shall be considered as district courts within the meaning of this act, right? So it's an interesting thing that the district courts they're still state courts, but they're considered district courts under this act, every court of record, right? So what that means is that every district court should be acting like a court of record, but of course they're not. They're applying statutes, acts, ordinances, and codes on everybody. Okay. All right, to continue. And such courts have power to naturalize, right? So only a court of record has the power, only a state court of record has the power to naturalize. That's the important thing that I want you to understand about that particular sentence. All right, next. The Supreme Court of this state having exclusive appellate jurisdiction has no power to naturalize. And of course, they're talking about California. The legislature of California has, by express enactment, conferred jurisdiction on the district courts of this state, meaning their state courts, to grant naturalization according to the rules established by Congress. What can Congress do? Only establish uniform rules. They cannot have the power to naturalize, as it was stated up here. All of the courts of this state being courts of inferior and limited powers, and although some are courts of record, yet having only statutory and not common law jurisdiction. So what is that showing you right there? It's that statutory and common law jurisdiction are completely different. Two different jurisdictions. Okay? They have no power to grant naturalization, and any attempt of the kind by them would be quorum non judice or and void. So quorum non judice means it was never valid, right? Let's pull this apart now. Again, all other courts of the state being courts of inferior and limited powers, and although some are courts of record, yet having only a statutory and not common law jurisdiction. So could you have a court of record? So what they're talking about is that California, and in California's situation, the California Constitution specifically states that all courts in California are courts of record, right? So they can operate according to the course of the common law and under common law jurisdiction. But what most of them are doing is they're operating under statutes. Just so you know that you can have a court of record that's not operating as a court of record. Put it that way is the best way to understand that. Now to get into the case here. All right. So delivered opinion to the court, Murray C.J. and Brian J. concurred. It is an application on the part of an alien to become naturalized under the provisions of the Constitution and laws of the United States. It has been made directly to this court and has been resisted by several eminent members of the bar in the character of an amicus curiae on the ground that state courts have no jurisdiction of the subject matter. It might be a sufficient answer to the applicant to declare what is the settled decision of this court, that it is under the state constitution an appellate tribunal and can take no original jurisdiction, however conferred. Now, of course, they're talking about the Supreme Court of California. But the importance of the question, which has been argued at the bar, and the learning and research which have been evidenced in its examination, induce us, in departure from our usual habit, to consider and determine the proper construction which should be given to the Constitution and laws of the United States in respect to the question of naturalization. Two propositions which have been made by the counsel opposed to the applicant will first be disposed of. These are, first, that the power to naturalize by virtue of the Act of Congress of 1802 is a judicial one, and second, that Congress has no power to confer jurisdiction upon the courts of a state. Upon both of these propositions, we firmly concur. It is a judicial power because upon evidence a conclusion has to be attained resulting from the exercise of the judgment of the court, right? So you have facts, law, and evidence put into a court of record, and then to be able to come to a resulting judgment. That's what a court does. This is simple and clear enough without resorting to authority, but nevertheless we will refer to such and such case where it is distinctly so settled by Chief Justice Marshall. Congress has no power to confer jurisdiction upon the courts of a state because first, the Constitution gives it no such power, and secondly, the Constitution expressly declares that, quote, the judicial power of the United States shall be vested in one Supreme Court and in other inferior courts as the Congress may from time to time ordain and establish, right? So this is where you're getting into this fact that the state courts and the federal courts are two different sets of courts. They're two different jurisdictions, okay? Dealing with two different aspects of subject matter. The Constitution thus fixed where the judicial power shall be vested. It cannot be vested elsewhere, right? Because power, remember, power is always vested. The power came from us. We vest that power to them in constitutions under good behavior to go do what we tell them we want them to go do because we're too busy living our lives and doing other things, right? But the power is within us. So the power to establish and create a court exists with the sovereign people. It does not exist in any government. It is vested to government by the people because we, the sovereigns, can create our own courts and have the right to create our own courts whenever we wish to. Okay, so to continue. There have been various adjudications maintaining this view, which will be sufficient simply to cite Martin versus Hunter's lease, so and so forth. It was urged in the course of the argument, and some authorities were cited, to the effect that, although Congress could not confer jurisdiction on a state so as to compel its exercise, yet it would be legitimate if the court was willing to accept it. Meaning the state courts have to say, okay, we go along with your uniform rule, that's fine, and that's how we'll do things. But it says, this to me is solecism. A court is a creature of the Constitution and laws under which it exists. To exercise any power not derived from such Constitution and laws would necessarily be a usurpation of the Constitution, whether state or federal, doesn't matter. It sounds curious to say, quote, Congress has no authority to give this power to the court, yet the court exercises this power by virtue of the authority of Congress. Okay, fine, but that's double talk, because what the attorney's really saying is an aspect that, well, it's funny to say that, but the truth is that in the federal Constitution, the only thing that the feds were granted was the power to create uniform rules, not to exercise the power of naturalization. That has to be done in a state court of record. Okay? There's no other way that can be done. All right, to continue. I come down to the consideration of the main questions, whether the state courts of California, and if so, what state courts have the power to naturalize? ? And I have come to the conclusion that this question is but little affected by the propositions which I have already led to consider on account of the seeming importance attached to them by the learned counsel and the able manner in which they were presented. In Section 8, Article 1 of the Constitution, enumerating the powers of Congress, is the following separate clause. Quote, to establish an uniform rule of naturalization and uniform laws on the subject of bankruptcy throughout the United States. Close quote. Now this is where it gets interesting. The metaphysical refinement in examining the form of our government, it might be correctly said that there is no such thing as a citizen of the United States. But constant usage arising from convenience and perhaps necessity and dating from the formation of the Confederacy has given substantial existence to the idea which the term conveys. But however, what they did after the Civil War, because remember, this is 1855 that we're reading this from. After the Civil War, what they did was they used the regular vernacular that everybody was using, and then they codified it and made it mean something else, so that everybody was then under the subject and under the jurisdiction of Congress under the 14th Amendment. Therefore, then being a citizen of the United States, because they chose to define it, and I said codified it, and defined it then as a specific thing in law. So that when people were running around using this term in whatever way that they felt it meant to them, now they come along with the 14th Amendment, they codify it and create and give it a definition. And so then when you start to say it, or you were to say it in open court or something, say you did that, it would then mean something else. And that's the attorney for you. That's attorney work product doctrine. That's the law merchant. That's the attorney selling you his law to alter, based upon the changing of market conditions, to alter the law to fleece everyone. That's what attorneys do. That's all they do. That's all they're good for. Okay? All right, get off my soapbox. To continue. A citizen of any one of the states of the Union is held to be and called a citizen of the United States, although technically and abstractly there is no such thing.
Oh, I'm sorry. I just want to point out real quick that you can also use this case to destroy the concept of state sovereign immunity.
Well, the other thing about destroying state sovereign immunity is there are a couple court cases which a friend of mine found that specifically that the states, particularly the state courts, when the state courts try to do something that's outside, they're not a court, they're not proceeding according to the course of common law, and say the state courts do something that is a substantive attack or destruction of your rights, and you sue the state courts, and the state courts try to come back with, well, we have sovereign immunity, you can't sue us under the 11th Amendment. Well, what this one federal court judge did is they demanded, when someone filed suit against the state courts to do this, the state courts answered with, we have sovereign immunity. Well, the federal circuit court judge told all of them in that case to go and brief out three specific cases. And each one of them stated that because these state courts have separate purses from the state, meaning they're private for profit corporations, they're separate private corporate courts with their own purses, they are not connected to the idea of sovereign immunity, and they can be sued. And
Well,
that,
I'm talking about when you want to directly sue the state. The state itself cannot fucking claim sovereign immunity because it's derived from the people.
well, from that
And
standpoint, yeah, but from that standpoint, you're wrong because of the 11th Amendment. The 11th Amendment does actually lay it out that you cannot do that. However, what I just said, you can do because they're not part of the state.
okay, yeah. So you just say, okay, show me your accounting. Oh, you have your own books. You're a separate corporation. Fuck you, pay me.
Yep, exactly. That's the point. That's how it works. And that's how you can separate these things out because none of them are operating under that sovereign immunity of the state. They're all operating as separate corporations. Even the states themselves are acting as separate corporations, which of course you could also argue and say you are not the original government of and under the original state constitution. You are a corporation, and so therefore you have no sovereign immunity. And so, yeah, you could go that route too. So, okay. So, all right. Back to this. Okay. So, a citizen of any one of the states of the Union is held to be and called a citizen of the United States, although technically and abstractly there is no such thing. To conceive a citizen of the United States who is not a citizen of some one of the states is totally foreign to the idea and inconsistent with the proper construction and common understanding of the expression as used in the Constitution, which must be deduced from its various other provisions. The object, then, to be attained by the exercise of the power of naturalization was to make citizens of the respective states. Okay? That was the point of naturalization, was the object was to be attained by the exercise and power of naturalization was to make citizens of the respective states, not to make some sort of newly created thing under the 14th Amendment called a citizen of the United States that's subject to the jurisdiction of Congress. Now, there's a few more points in here, and then I'm going to get to the remedy of the proposed remedy that I wish to propose to everyone about how we can fix this once and for all. Okay. All right. So at the time of the adoption of the Constitution, the states had power to make citizens of aliens. Obviously, does the clause of the Constitution above quoted deprive them of it? Question mark. And of course, no, it doesn't. The true rule of construction as to the exclusiveness of the powers of Congress is first that it must be granted exclusively. Second, forbidden to the states, which it is not. Third, from the nature of the power it's exercised by both must be incompatible and incongruous. Right, makes sense. Does the power under review come within either of these positions? We examine the language closely, and according to the rules of rigid construction always applicable to delegated powers, we will find that the power to naturalize in fact is not given to Congress, but simply the power to establish a uniform rule. Right? They don't have the power to naturalize. They only have the power to create a uniform rule that all the states then need to basically abide by. But must be done in state courts of record, common law courts, not equity courts. Okay? All right, to continue. The states are not forbidden to naturalize, nor is there anything in the exercise of the power of them incongruous or incompatible with the power of Congress to establish a uniform rule. That the states, if they choose to exercise the power as an original one, must abide by the rule which Congress makes. There cannot be the slightest difference of opinion. The power given to Congress was, according to my apprehension, intended to provide a rule for the action of the states and not a rule for the action of the federal government, which it clearly states. Else why was the term uniform made to qualify rule, the word rule, right? Which is sentence construction, right? If it was designed simply to give the power of making citizens to Congress, simpler modes of expression might have been used and ought to have been required, and surely there would have been no use for the term uniform. Why should the rule be uniform unless more than one had to execute the rule, meaning all of the separate state courts of record, right? It certainly could not have been imagined that Congress would have made a rule for its own action or the action of its own officers, which could have operated without uniformity, right? The states had the power to nationalize foreigners, and there was no necessity for this power to be surrendered to the general government. But by another clause of the Constitution, Section 1, Article 4, it was determined that, quote, the citizens of each state shall be entitled to all the privileges and immunities of citizens in the several states. And by the way, this should be a capital C citizen here, and this should be a capital C citizen here. I don't know why they didn't put that in there correctly, but anyway. Because lowercase s citizen doesn't start to exist in the Constitution for the United States of America until you get past the 14th Amendment. In the 14th Amendment, it has a lowercase s citizen, right? Meaning it's not a proper noun, it's a descriptive term. Basically, I guess that would be what, an adjective? That it's a descriptive term of the citizen of the United States of being subject to the jurisdiction of Congress. A capital C citizen in the federal Constitution is a citizen of a state. Okay? Just so you know that. I don't want to get anybody confused about lowercase and uppercase stuff here, because they did not put this in here correctly. It might well have been apprehended that in the feeble and sparsely populated condition of the states, a race would have been run for the acquisition of population, differing in its radicalism only according to the difference of opinion as to the danger of the sudden introduction of too large a foreign element, and as, when once admitted to citizenship in one state, the alien would have all privileges in all other states. Obviously, it would be in effect allowing one state to modify or break down the policy of another. This is made apparent by the discussion which then took place upon the subject, right? That's why the clause exists in the federal Constitution, that the feds have the power to create a uniform rule so that each state wouldn't be creating different rules and say, well, you can be a citizen over here, but, you know, New York doesn't agree with how Pennsylvania decided to naturalize a citizen, so therefore
Yeah, it just
citizens that
made
were
uniform
naturalized in
reciprocity.
Pennsylvania cannot be citizens then, or cannot be considered naturalized citizens in New York, and you would have the two states then basically fighting each other and warring over that. So that's why the discussion happened that said, nope, we're going to make it uniform, it's going to be complete, and it's going to be on the federal side and be done with it. Okay.
Yeah, that's just a total reciprocity thing, and that falls under the full faith and credit thing as well.
Right, which was already mentioned in here. Since the necessity arose that Congress should have power to naturalize, but should have no power to prescribe to the states a rule to be carried out by them, and which should be uniform in each, if this were not so, it follows conclusively that there is no mode by which a foreigner can be made expressly a citizen of a state. For I have already shown there is no such thing technically as a citizen of the United States. Of course, again, remember, this is 1855 we're talking about here. This is pre-Civil War. Consequently, one who is created a citizen of the United States is certainly not made a citizen of any particular state, right? Which is what the feds did after the Civil War. That's what they did when they freed all the slaves. They put all of the slaves under the federal government, not the state governments, but under the federal government. All that happened literally in law is they went from being private property to being public property under the United States Federal Corporation, or United States Federal Trust, I should say. And because of
Yeah, it was just a
they
big asset forfeiture is all it was.
they gave them the connection to say, okay, you have now what's called civil rights. Civil Roman civil law is municipal law. We the people, anybody that's not a citizen of the United States, we the people are above Roman civil law. It is foreign to us, which is clearly stated in the title of Bouvier's Law Dictionary, where it states that this law dictionary is for the Constitution, adopted for the Constitution of the United States of America, and the civil and other forms of foreign law. So Roman civil law, also known as municipal law, which is is what DC is run by, and is also what all your cities and counties are run by, municipal law. None of that law was ever, 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 ever meant to be put over the top of us as people, ever, because we're not subject to it. They're subject to our rule, they're subject to our law, they're subject to our contracts, which are the constitutions. And it's a contractual relationship. We created the Constitution, we put it out there, we said if you guys decide to take an oath to uphold and protect it and put up your bond, then you can then be a public trustee to go do these various different things that we've vested you with power to do and under good behavior. And if you do not operate under good behavior, well, then guess what? We get to take it away from you. And we also get to indict you for all kinds of other things for damages to us and criminal charges and whatnot. Okay, so to continue, it follows that as it is only the citizens of the state who are entitled to all the privileges and immunities of citizens of the several states, if the process is left alone to the action of Congress through her federal tribunals and in the form which they have adopted, then a distinction both in name and privileges is made to exist between citizens of the United States, ex v temerity. Okay, I don't exactly know what that Latin means in that context, and citizens of the respective states. So yeah, so that's the point. And then what did they do after the Civil War? They came along with a system to create a separate and different citizen, right?
Hey, can you snip that Latin you couldn't get into chat, please?
I could just type it in; it'd be faster.
Okay, literally, the translation means from the force of the boundary.
From the force of the boundary. Okay, makes sense. Yeah, because the force of the boundary was it would be impossible. Okay, so let's read that sentence again now, knowing what that means, so we can get the context of it correctly. Okay, it follows that as it is only the citizens of the state who are entitled to all the privileges and immunities of the citizens of the several states, if the process is left alone to the action of Congress through her federal tribunals and in the form which they have adopted, then a distinction both in name and privileges is made to exist between citizens of the United States from the force of the boundary and citizens of the respective states, right? Because there would be a boundary between a federal citizen and a state citizen, which is exactly what they did after the Civil War. That was precisely what they did. Okay. To the former, which would be a citizen of the several states, or sorry, to the former, what? Sorry, it would
Okay,
be
another one is by the force of the limit. Sorry, but
all
it's
right.
either the force
Okay.
of the boundary or force of the limit.
All right. I got to get this. Okay. So the former, which would be a citizen of the United States, this thing that didn't exist at this time, right? So to the former, no privileges or immunities are granted. So get that. To the former, which means the citizen of the United States, no privileges or immunities are granted. And it will hardly be contended that political status can be derived by implication against express legal enactments. So that is an extremely important part of this case, is to understand just what was said right from there, basically from there to there, that whole little snippet. Okay? Because they literally just said to the former, meaning the citizen of the United States, no privileges or immunities are granted, because the thing it's not something that actually exists. You can only be a citizen of a respective state, right? At this time in 1855. Again, what they did after the Civil War and Reconstruction of the 14th Amendment is a whole different story. They came along with and said, "Oh, well, let's do this. Let's create this other thing," right? Okay. All right. I cannot concede that such a result was ever contemplated, and yet it would be inevitable upon any other hypothesis that the, quote, uniform rule, close quote, declared by the Constitution was intended to be prescribed for the action of the states, and that by this rule they were left to exercise or not their original power of naturalization. The next inquiry, which is in proper order, whether the state of California has determined by her legislation to admit foreigners to the rights of citizenship under the uniform rule established by the various acts of Congress. This question, in my opinion, is settled in the affirmative by the act passed in May 18th, 1853, again, pre-Civil War, entitled An Act to Define the Fees to be Charged by the Clerks of Courts for the Naturalization of Foreigners. That would be an interesting thing to go find. This act, after providing the amount of fees to be allowed the clerks in the process of making citizens, declares, quote, and said papers herein provided shall forth be issued by the court upon application for an individual entitled to receive them, and upon his complying with the provisions of the naturalization laws. Right. So again, this is the state courts. This is the state courts creating or using the power, but under what? Complying with the naturalization laws, which Congress makes as uniform laws, right? And then much criticism might be indulged upon the form of this law and upon the fact that its caption shows that it was intended only as a fee bill. But it must be conceded that in the construction of laws, the principal consideration is the intention of the lawmaker. Governed by this rule, I have no hesitation in saying that the act in question is equivalent to a direct and palpable declaration by the legislature which enacted it, that it recognized the rule of naturalization prescribed for the states by Congress and determined that the courts of this state of competent jurisdiction, meaning courts of common law, should be vested with the power of carrying it out. Okay? If this were not so, there was no reason whatsoever for passing the act, and courts cannot decide an act to be inoperative where a substantial meaning and design can be drawn from its expressions. In this act, the courts are vested with jurisdiction, for they are required to issue the certificates of naturalization and to determine that the individual is entitled to receive them. This is where I want to pause here and get into the remedy. Now that we know all this, and this specific part right here, just this sentence literally, from here to here, in this act, the courts are vested with jurisdiction, for they are required to issue the certificates of naturalization and to determine that the individual is entitled to receive them. Okay, what courts? State courts. What specific kind of state courts? Courts of record. Common law courts of record. Why could then we not literally go to the states and say, hey, I demand that you create a document or acknowledge my proper status as one of the people of such and such state, and then sue the state in a court of record if they fail to correct your status. Now, there's two different ways to do this. We could do this at law in a court of record and say that this is what I'm suing for, and it's a requirement that you do so, and here's all the provisions, and here's the reasons why, and here's the law, using Ex-parte Knowles here, and saying that the state courts of record are the only places that this can happen. Or, because everything is being run by equity, everything is, the whole entire system is now all equity. Well, okay, there's a remedy for that too. In equity, there's a specific judgment, and it's called a declaratory judgment. Now, what a declaratory judgment does is that, and you can look this up, you won't be able to find declaratory judgment in any old dictionary. You're only going to be able to find it in like newer blacks, because it literally has not even been around all that long. It's really only been around as a remedy for all of the debacle and bullshit that they did in 1933. Because what it is a case that it's done in equity, so it's under equity jurisdiction. And what you're doing is, all a declaratory judgment does is it establishes the relationship of the parties. It does not ask for damages. It's not a criminal matter. That's all it does. It just establishes the relationship between the parties. And to give you an example, well, you know what? I'll get to the example in a second. Okay, so how we want to use that, if you wanted to use that in equity with the state, is go, okay, look, I've served the state with the entire vocational science and freedom status doc set. I've declared, and in the vocational science and freedom status doc set, we have what's called a declaration of nationality, where you state that you are a de-jure state citizen, that you're one of the people of that respective state, right? And it states the law in the document, the federal law, that specifically states that under the Expatriation Act, that any officer, meaning state officer or federal, when they're presented with a document of declaration regarding nationality, it cannot be denied, and they basically have to go along with it. And that's also reflected, not to make too fine a point here, but it's also reflected in the federal FOIA. Now, how the hell does federal FOIA and naturalization and the Expatriation Act all get connected? Well, it gets connected in Title V, 552 AE. If you go read Title V,
real quick, see what I typed quick.
If you go read Title V, 552 AE, what it'll show you is that if they hold a record of you in any way, shape, or form, and that record is either incomplete or incorrect, you can demand that they correct that record. And that is protected, at least on the federal side, under that specific part of FOIA. Okay. Yeah, and that's the reason why we created the de-jure confirmation, which which is like one of the last documents that you can do after you've gotten all the rest of your status doc set done. You can come back and you can regather your petite jury with your judicial coroner, and then you can create and do the de-jure confirmation. And what the de-jure confirmation is that it's a court of record. A jury is finding by a court of record that you are who you say you are. It's basically confirming all of the rest of the status docs. And that's something that we just got done with. So it's not something that's out there for everybody else that's already got their status docs, meaning it's something that I'm going to have to basically put it up on the server as kind of a finishing document, because anyone that's done the status docs can do it. Also, anyone that's done the status docs, also in the price sheet, it clearly states that any update of any of the status docs are always given out to everyone for free, because once you pay for the status docs, you get all of the updates for life. So yeah, that the aspect of that de-jure confirmation is also part of this process. But the specific point about suing the state for the declaratory judgment is then something that the state will have to abide by, and they will have to correct. Because once a court has ruled on something, even if it is an equity court, doesn't matter, that they then have to correct the status. That's where the solution of this gets into. Okay. All right. So that's the part and parcel of where I was getting to getting the solution. So I'll continue now. I think there's one other part of this that had some meat to it. Okay. So what, however, are the courts of competent jurisdiction? Question mark. To answer this, we must turn to the Act of Congress of 1802 and be governed by the rule there established. Congress, having power under the Constitution to make the rule, certainly had the right to make the exercise of it a judicial power and fix upon the class of courts which might be vested with the jurisdiction. This it could do as part of the rule, although it might not directly confer the jurisdiction, because obviously it can't. By the third section of the Article 1802, it is enacted that every court of record in any individual state having common law jurisdiction and a seal and clerk and or prothonotary shall be considered as a district court within the meaning of this act. So what were they creating? They were establishing the district courts. The feds were calling state courts by a different name. Did that change what the state courts were? No. Why did they do this? So that they could determine what courts could have the power to naturalize someone. Basically, that's why they did it. And the last paragraph here, we have already determined that this court has not the jurisdiction because its powers are exclusively appellate. Now, of course, they're talking about the California Supreme Court, okay? They're not talking about the courts of record on the state side. They're talking just specifically about the California Supreme Court here. The district courts of this state are courts of original and common law jurisdiction, are courts of record, and have a seal and clerk, and consequently come fully within the description of the rule laid down by the Act of 1802, and therefore under the Act of this state of 1853, are fully vested with power and jurisdiction to naturalize foreigners who exhibit the qualifications fixed by the laws of the United States. The other courts of this state are inferior and of limited powers. They are made courts of record only by our statutes, but they have only statute and not common law jurisdiction, and therefore, not coming within the class enumerated by the Act of Congress, have no power to grant naturalization, and any attempt of the kind would be necessarily quorum non judice and void. For the want of jurisdiction in this court, the application is denied. And of course, they're talking about the California Supreme Court, because remember, that's where this thing was brought. It was brought in the California Supreme Court. So don't pay attention. Don't get all worried and say the application is denied. Well, it was denied because the California Supreme Court doesn't have this original jurisdiction. Now, again, to make a point here about courts and powers, the state courts of record are the highest courts in the land. They are. And even the Supreme Court of the United States has said that. The Supreme Court of the United States specifically stated that the decision of a court of record is as conclusive on this court, meaning the United States Supreme Court, as it is on all other courts. It puts an end to the issue of the facts by deciding them, or something like that, I think, is what it says. So because of that, you also see the fact that any decision that is made by a court with a jury, that no decision by a jury can be overturned by any other court in the United States, federal or state, doesn't matter, unless it's according to the common law. Okay, what does that mean? It means when we hold our courts of record, by our judicial coroners holding our courts of record, where we fill out, fulfill, and do the proof of life and proof of age inquest in our court of record by a petite jury, there is no court in this land that can overturn that except by the common law. They are so far removed from the common law now, they wouldn't even know how to do it even if they wanted to. Because what they would have to do...
Can't anyway.
Yeah, they really can't anyway, because it's a matter of life and limb. So technically, it must be considered gratis, so that we got them coming and going. There's no way out of this for them. None. Okay, so anyway, that's Ex-parte Knowles. Now I'm going to get into the committee aspect of how we're going to organize this and how we're going to get these issues and these things taken care of in a way where we'll all be able to know what's going on. We'll be able to help out in whatever way, shape we can to finish these tasks, like writing the declaratory suit for declaratory judgment against the state regarding status, right? Okay, so what you see on the left-hand side of the screen here is I've created a mega folder for the Vocational Science and Freedom Task Committee projects. Now, I haven't had them all filled out yet, but they do follow in order along with the VSOF Task Committees. So what we're going to have is we're going to have one voice room where in that voice room, I will add all of the different voice rooms here for each committee all the way down. So there'll be voice room 1, voice room 2, voice room 3 for each committee, okay? So, but there'll only be one main voice lobby, but they'll have different rooms underneath it. The committee announcements, this is where I'm going to post everything as far as the organization. And I've already started to get this up and running. Okay, so this is the general organization for the VSOF committees. The goal of the VSOF task committees is to learn the facts, meaning the who, what, when, where, why, of the tasks or subject proposed by the VSOF community. So anybody can propose a new committee. This is where you do it here in the forum section. So if you want to propose a new committee for something, put it in here, say why it should be something that should be researched, and put it up. And then, we'll determine and say, okay, yep, we'll add it, or nope, it's already covered under some other committee or whatever. Okay, it's okay. So the purpose of the VSOF task community, and find solutions to those task subjects listed and give a bi-monthly report to the entire VSOF Gilded server of their findings. Now, I'll set a separate day for that, whether it be Thursday, Friday, Monday, Tuesday, whatever, something that's obviously not on Saturday or Wednesday. And again, to accomplish this, everyone is required to watch the VSOF lectures on the Trivium before they sign up to join a VSOF task committee. And they're not that long. There's 3 of them that I did, and it completely covers the Trivium so that you know how to organize your thoughts and how to discern a fact from a lie, basically. All right, 2, a committee or commission is a body of one or more people that is subordinate to a deliberative assembly. So we are the whole assembly, and then the committees will be separate parts of us doing our thing. Usually the assembly sends matters into a committee as a way to explore them more fully than would be possible if the assembly itself were considering them. Committees may have different functions, and their type of work differ depending upon the type of organization and the needs, obviously. So we have these, they're all organized on the side here. And I said, or I've put up, and each one of them eventually may have their own specific forum, but at least I've got the specific committee set up. So open source everything, preppers committee, settle our estates, and then there's a registered agent list and a forum for settle our estates. So these 2 are underneath number 3. Number 4, private ID for the house. That could kind of be something that could be brought up under settle our estates, but I really do want people separately researching that. The birth certificate, everything about the birth certificates, everything, where they came from, where they started, what they are, all the information, right? And then there's a forum for that. Arbitration, I'll probably put a forum under arbitration also, so we can have a forum for arbitration. DTCC research, right? So there's a forum for that. Grand jury committee, forum for that. Control public trustees, I may or may not alter the title of that one, but for now I'll leave it. Land rights and allodial title, and then committee, or sorry, and then the forum for the land rights. End Roman civil law. This is going to be everything else dealing with equity, dealing with the Roman civil law system, whether it be traffic tickets, fines, criminal nature stuff, IRS, well, for the exception of IRS, because I do have IRS as a separate issue, but basically anything that the corporate state is going to try to charge your estate with, or the
I have a suggestion about that.
constructive trust.
With the throw a clause in the kill warrant contract that basically says that the parties hereby agree that the civil/municipal law is no longer binding or applicable in any manner.
It's already in there. Yeah, it's in there.
Oh, okay.
It's covered.
Like I said, it's okay. It's 90 some pages, and I haven't read it in a while. All right, fine.
Yeah, we put that in there. It's under binding law, and it's also a requirement under contract once they become a bound trustee. Once they administer any part of the estate, they agree that basically only the declared law of your house, meaning the law of the domicile, what you declare to be the law in your courts of record, and the governing law, which is also stated in the contract itself, is basically the only law that is applicable. So yeah.
Oh, that's right. We stole that out of those VAX contracts anyway. I forgot.
Well, it came up again in the VAX contracts, but it was technically in there prior to that. I just went back and relooked at it, and I was like, oh, okay, yeah, it was already in there. So even though we came across those vaccination contracts for whatever it was, Albania, that we found them in there, we had already had them in the KW anyway. So, all right, so to continue here with the organization part of it. So the VSOF task committees are rooms where specific topics of research and study are proposed and open up to everyone in the entire server to be able to join in and help, but are limited in the amount of specific officers for each committee. And I'll get to the officers in a second. Number 4, each committee will have a chairman or chairwoman and special master appointed based on the knowledge of the applicant regarding that topic task. If the specific committee needs one or more VSOF scribes will work on the creation of the documents, letters, notices, court paperwork, and anything else that needs to be created by writing. So meaning that if it's strictly a research committee, there won't have to be a VSOF scribe assigned to the committee. However, if the committee itself is something that is going to require creation of paperwork, like say for example, the private ID for your house, then we'll make sure that someone, and I'm going to reset the roles because I had a VSOF scribe role and I altered it. So what I'm going to do is I'm going to remake the vocational science of freedom scribe role. And if you have the capacity and knowledge and ability to write paperwork, court paperwork, notices, and the like, and you've shown that to me or shown it in bringing forth documents that you've created, then I'm just going to automatically give you the role. And then what I'll do is I will create an announcement, put it up in the announcements for the server up here under the VSOF server announcements, that these will be the parameters of which you can ask for and then be granted a role as a vocational science of freedom scribe. Okay, so the specific tasks for each subject stated are given in the description of each committee room, which I've already laid out most of these. Like I said, I was just getting kind of done with it before class tonight, so I'll finish up the rest of it tonight. Some committees are assigned a separate forum to better keep track, which I mentioned. VSOF guild members are limited to only being on 3 task committees at a time, because I don't want people, being in every single committee, because I want you to be able to. I want everybody to focus on what the task is and not get too scatterbrained about it. Number 9, each committee is asked to give a bi-monthly report to the entire server as to their findings and conclusions each month regarding the committee's goals and tasks. This will vary according to the workload and output of the committee, meaning if it's a one-time thing that we're trying to solve or get done, then obviously you don't need to be giving a report twice a month. You can just give a report once a month, or you can just give the report when you finally figure out what it is that you've researched or the task or problem has been solved or figured out or written or whatever it is. And then number 10, please refer to the announcement regarding organization of the positions of the VSOF Task Committee to learn more about the organization. And then this is the mega folder that I put up for all the task committees, which, as I showed, is not full yet, but I will flesh out the rest of them tonight and make sure that each committee has its own folder. And I will put the link, and that's of course the main link, so everybody can get to it here. If you want to be a part of the committee, meaning if you want to either be a chairman, a special master, or a scribe, only the chairman, the special masters, and the scribes will have read and write access. So then they can post what they need to, and everybody else can just look at it and download it. In the announcement, this is the organization of the positions. It describes the chairwoman, chairperson, chairwoman, chairman, the special master, and then what their duties are, and then how the organization is going to be set up, the members, how to set up the mega account if you want to be a chairman, chairwoman, or a special master or a scribe. And I will do a separate post, a separate announcement regarding how to qualify as a scribe. And what I'm going to do is I've literally created a separate group off of the side underneath VSOF, and you can see it here. The whole VSOF server is going to be slightly redone. And what I'm going to do is I'm going to pull a lot of these larger sections that I have in the VSOF server. I'm going to put them into being separate groups. And I might pull the entire task committee into a separate group. I will probably most likely pull the whole entire reference section into a separate group over here so that the VSOF server itself isn't so busy, I guess is the best way to put it. We'll do that, pull it over, and create the different groups down here. That will be the organization for the task committees and how we can get them set up. And then I will be posting announcements in the main announcements room for people to start signing up and to start to get going with these things, because even if you can only spend a couple hours a day researching something, you find the information, you post it, you either create a forum for it and say, hey, I found such and such, or just post it in the chat room, and then with links that people can then stem off of to gather the rest of the information needed to accomplish the task, then so be it. That's fine. The way that we'll be able to accomplish things much, much faster is that if everyone works together and we do it in an organized fashion based upon grammar, logic, and rhetoric. That's the proposals as far as the committees are concerned, again, always open to suggestion. Here, you can also just put various different suggestions directly to me is fine. That's all of the VSOF task committees, and there might be more that we can create later, like I said, and we'll run these as we see fit, and I'll open it up for people to be chairman or chairwomen if they wish, and we'll see how many people sign up, and we'll see which committees get filled up first, and we'll run it like that. And I'll make sure to also, I will probably cut this tonight's class. I'll probably cut tonight's class into two separate classes. I'll probably cut the section regarding everything that I talked about earlier tonight about naturalization and about using the common law courts, state courts, and then cut that separate from this explanation of the task committees so that when I post it onto the YouTube, that people will easily be able to just go and watch the task committee class. So that's it. That's all I've got for tonight as far as those two subjects. So that's tonight's class. And so I thank everybody for showing up. And I thank everybody for coming and listening. And if you're listening online, please join the server so you can contribute to our Vocational Science Freedom Gilded server. And with that, everybody have a good night and stay safe and stay sovereign.